5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on, this is not slavery. I mean, not the one. I am not the one. I don't even have a license. What's your license number?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you, and I'm not going to start now.
This defendant is facing a felony retail fraud charge, and instead of focusing on his arraignment, he starts arguing with the judge about whether he even has to answer to her. He's looking at up to 5 years in prison and a $10,000 fine. Rather than addressing the charges, he begins talking about how the system doesn't apply to him and brings up unrelated arguments. He also seems unsure whether he wants legal representation or to represent himself, which already sets the tone for how this will go. If you were facing 5 years, would you challenge the court like this? Let's take a look.
25S00791. FYI, people say the Michigan versus Timothy Dansby.
Secretary on behalf of people.
Illinois 87146, stating in for the attorney of record, Gonzalez, and appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state the name for the record?
My name is Timothy Dansby, and I'm about to represent myself and take counsel as an assistant. You know what I mean? I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received by discovery. Okay?
Well, that's what we got lawyers for, sir.
The count machine to get to the lawyer very well to the county. So it's paying me hard. Don't want to need some type of system.
Okay, well, that's what we did for you. Okay.
I'm going to represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I want to go ahead on with the document.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge,
I believe it's 5 years.
yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
Tell them I got a brain go.
You can have a, but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
He wants to represent himself, but also wants a lawyer because he can't get the paperwork he thinks he deserves. I mean, that right there is why you don't represent yourself. It's like saying you'll perform your own surgery, but still need a doctor to guide your hands. I mean, you either trust the professional or you don't. You can't switch back and forth every 5 minutes. And like, the judge can literally see this dude doesn't understand basic procedure. Confidence without knowledge is so dangerous in a courtroom. I mean, this dude's arguing about discovery at an arraignment like he's in a TV drama too. I mean, buddy, this isn't Law and Order. It's paperwork in process.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one to commit it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dansby today, and have not received any audio-visual discovery time today.
I like to be honest, mind. Probably mostly, I'm saying, for the fact that I haven't been denied, I'm saying, in the time about it, I'm saying, in the prosecutor was conduct, you my government change, even though
Okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, dog.
Sir, do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So, the first hearing, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
Just stand here and just say, oh, yes, come on, this is not slavery. I mean, not the one. Constitution. I am not the one. I don't care nothing about the United States. First of all,
Apparently not.
court.
You must not care too much about anything, sir. Okay.
I don't even have a license. What's your license number?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't care. That's why you're here charged with something.
What is your license number?
I don't have to answer you, and I don't answer to you, and I'm not gonna start now. You need to settle down. You don't need to settle down. Okay, take him out of here, please. That's okay. He's just having his moments.
Bringing up unrelated historical arguments in a retail fraud case doesn't really help his situation. Instead of presenting a defense, it comes across as a distraction. When the judge responds firmly, it's a clear sign that his approach isn't working. Courtrooms are focused on facts and legal arguments, not broad debates about the system. The simplest way to move forward would be to answer the questions and follow the process, but instead, he turns the hearing into an argument. When someone rejects the legal process entirely, it often makes their situation more difficult rather than improving it.
So we're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right. So we'll give you. What do you think? You could just need video.
Yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's gonna want to see it, so you're probably gonna need to have him take the laptop over there to the jail and take his license to practice law to him. Okay. All right. So the next probable cause conference on this charge is gonna be.
I just to make a record as regards that discovery. I do have paper discovery, which counsel has noted that has been tendered already. I do not have. Does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Garlick will be in trial in the Wayne County Third Court. I make that paperwork for myself, but if you're wanting Mr. Garlick to be here,
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance that I would be more comfortable if Mr. Garlick just handled his own.
Well, you know what? You gotta cut your teeth somehow. We all had this.
Just don't.
Ask Miss Gracie, okay? Ask Mr. Puda. We've all dealt with difficult clients.
We got this crazy. He's an expert in us.
I've had my share over the years when I was licensed to practice law. So, by his standards, I'm not licensed. Okay. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Ghani visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
The judge gave him several opportunities to calm down and cooperate, even warning him about possible consequences. Despite that, he continued to argue. There's a big difference between understanding your rights and misapplying them. Facing a potential 5-year sentence isn't the time to take risks with self-representation without proper knowledge. Situations like this highlight how important it is to approach court seriously. What do you think? Would you ever represent yourself in a felony case? Thanks for watching, and don't forget to like and subscribe.